Good evening, friends, and welcome to another edition of Crime Time with DutyRon and Ed Wallace. We are retired New York City police detectives and 9/11 World Trade Center first responders. If you like all things true crime related from the police detective's perspective, hit that subscribe button, hit that notification bell so you'll get all things DutyRon and this guy, my partner right here, Ed Wallace, when we go live or upload another video. Hey, today in the Karen Reed trial, Alan Jackson delivered a powerful closing argument. It was closing arguments from the defense. They went first, which is not what we're used to seeing, and then the prosecutor, Hank Brennan. And boy, did Mr. Jackson deliver a doozy, breaking it down without all of the objections, uninterrupted. Ed, your thoughts on closing arguments today?
Alan Jackson went long. He went long ball today. He went yard, as they say. He hit it out of the park, whatever you want to analogy you want to use. He was great. As I was on another show earlier today, I was also saying that, I thought he could have added a little more emphasis on certain issues to nail down the fact that tail light was most likely broken inside of the Sally Port. With the missing salt water. Other than that, I give him 2 thumbs up.
Yeah, he broke it down at the lack of investigation at 34 Fairview. I love that he put the Alberts on blast. He talked about Brian Albert being the homeowner and a first responder, and he did not come outside. He emphasized that. What I also loved about his opening is that he said, I wrote it down on page 2. I only had 2 pages of notes. No collision, no collision, no collision.
Game over right there.
Right. And that was in response to the Commonwealth's, I hit him, I hit him, I hit him. And I thought it was a great, he set it up perfectly. He hammered it home. It was emotional. He thanked the jurors, something that Hank Brennan did, but in a little different style. And Alan Jackson also thanked them at the end, whereas the prosecutor just walked away from them. I don't know if anybody caught on to that, but he just walked away when he was done talking. He didn't say thank you for your time. He didn't say thank you or anything like that at the end. So let's take a listen to this little piece, and then we'll come back and we'll get your thoughts.
Tonight, making their final pitch to the jury, the defense and prosecution face off in closing arguments.
Do not let the Commonwealth get away with this.
This tail light was gone. There's no boogeyman. There's no plan. There's no Hagen to the salad board.
The defense stresses the science as they urge jurors not to convict Karen Reed.
Science, the physics, the data, they lose. But tragically, Michael Proctor wins.
While the prosecution uses Reed's own words against her.
And that eyewitness tells us that she knew it. That eyewitness is Karen Reed himself.
But which strategy was more successful? Our legal expert weighs in. Plus, the jury begins debating Reed's fate.
You may retire and deliberate your verdict.
A juror from the first trial provides his insight. Canton Confidential, the Karen Reed murder trial starts right now.
After 8 weeks of testimony and dramatic closing arguments today, Karen Reed's fate is now in the hands of the jury. Good evening, I'm Glenn Jones.
I'm JC Monahan. 7 women and 5 men make up that jury. Today, they witnessed defense attorney Alan Jackson and special prosecutor Hank Brennan go head to head, doing whatever they could to convince the jury to believe their narrative of what happened on that night of January 29th. 2022. Melody Mendez was there. Melody, a lot of takeaways from closing arguments. What can you tell us?
Well, JC, listen, over the past 8 weeks, everything the jury heard in that courtroom is the same. The facts are the same. The testimony is the same. But what each side thinks that jury should take away from everything they heard, well, that could not be more different.
Courage is what this moment demands.
Injustice, according to Alan Jackson, is at the core of this case. And today, he told the jury to stare it down.
You folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth.
He closed his case using the same 4 words with which he opened it. There was no collision.
They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie.
Jackson pointing to 2 of the prosecution's own experts to show reasonable doubt. First, Dr. Welcher.
There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty.
Then Ian Whiffen.
If their own cell phone expert has a reasonable doubt about John's location, so should you. Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty.
Focusing more than once on the man behind the investigation, Trooper Michael Proctor, saying his case was corrupt from the start.
The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks.
Proctor's text messages.
Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him?
And what his investigation ignored?
You have a man laying dead in the yard, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away.
Cutting to the corruption they say is at the heart of this case.
On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us. At the expense of Karen Reed, an innocent woman.
Hank Brennan got the last word for the Commonwealth and started with a focus squarely on John.
And John O'Keefe lying helpless like a child on the front yard. She made a choice. She drove away. She was drunk. She hit him. And she left him to die.
That decision, he says, constitutes second-degree murder.
That's what this case is about. And the decision is that she steps on the gas after banging it into reverse.
Saying Reed not only knew she hit him, but pretended to find his body the next morning.
She does not see John O'Keefe. She knows where he is. She knows exactly where he is.
As for Michael.
And I want to stop it here because no matter what Hank Brennan says to this jury, the experts, the very experts that he brought on, proved scientifically that John O'Keefe was not hit by Karen Reed's SUV. Ed, how powerful is that to these jurors?
If there's no hit, you must acquit.
Yeah.
And the science is there, folks. The science and the medical evidence is there. The physics is there. No matter what Hank spews about the black box and going 33 feet forward at this speed and going 50-something feet in reverse at this speed, there's no collision with John O'Keefe. He cannot get around that. None of that. The debris field, okay, that's bullshit. It was planted, okay. He attacks the one honest cop in the entire case of cops that testified. He attacks the one honest cop, okay. The bodies weren't there. Jennifer McCabe said there was no body when she left, okay. The young man in the pickup truck coming to pick up his sister, those 3 people saw nobody. Okay. At that time, John O'Keefe was not seen by them in the car. There's no accident. No accident. There's no crime.
Amen, brother. And the list goes on and on and on. It's
insurmountable. You cannot get over that hurdle.
Right. And the real issue for the Commonwealth is that if they scientifically proved that John O'Keefe was not hit by the Lexus SUV, how could they charge these charges? Murder in the second degree, manslaughter, and leaving the scene of a deadly accident. And all of these 3 charges are impossible for the jury to come back and charge her with this because it's proven that she didn't hit him with the car. Yes, they could say she was operating a motor vehicle, but in that case, then you should be locking up the whole town of Canton and all these people that have been out there driving their car on that fateful evening, drunk. But yeah, so it's a sham when you look at it. And a couple of people in the chat were saying, "Oh, why wasn't DutyRon on with Melanie Little and Ed Wallace?" A, I was out with my wife. It's date night, and B, she just wanted Ed on for his expertise, which is fine. I never got an invite from her. He got the invite. I was out. I wouldn't be able to go anyways, but I love that he went on there because he added to the conversation. He was surrounded by a bunch of attorneys. So Ed, you held your own.
Surrounded by lawyers, and I put on Kevlar just for that purpose.
Yeah, absolutely. But yeah, it was good to see Ed on there. When he actually called me to say he was going on, I was sitting out to dinner with the missus. Friday night is date night. For those of you who know me for a long time, that's what we do. We go out on date night every Friday night. So I was unavailable, even if needed, but I wasn't needed. I never got the call or the text, but Ed did, and he represented us, and it was great that he was on there. Ed, I want to talk to you about the jury. Juror number 1 was selected by Judge Bev. He wasn't this, and it's an African-American male from reports from local affiliates. He was moved. The seat, remember there was that seating arrangement snafu where seat number 1 switched with, I don't remember what other seat, but
That was after she had Judge Bev had to interview all of them.
Right. And it involves seat number 1. So she went right to him and asked him, I don't know if she was going to go down to seat 1, 2, 3 and ask, but she was like, she made it like it was like such a big thing. Oh, I'm so glad that you accepted right off the bat without even hearing what I was going to ask of you. But it was just an odd moment in court. Murder in the second degree carries, if convicted, life in prison, up to life in prison. Manslaughter while operating a motor vehicle under the influence. I'm hearing different things. I wish we had an attorney here because I would ask the attorney. I didn't get a chance to look up Massachusetts state law, the penal law and the sentencing guidelines, but I'm hearing around 5 years if convicted of that. Leaving the scene of the accident and resulting in death, I think, is 1 year. But I'm not an attorney, so I don't know for sure. If anybody in the chat knows definitively, let us know, please. Nicole in the chat says, DutyRon, making sure his wife is happy makes me love and appreciate him even more. Yeah, thank you. I appreciate that. Sometimes, like I said, and I know how Ed is, he's the same way. If he had something to do with his family, he would put it aside, but he was available. He stepped up to the plate. I personally wouldn't have been available because I was out sitting at dinner. Let's go to the second piece that I had here. Boston 25, they did some coverage, but we saw a lot of support for Karen Reed outside the courthouse today. There's support there all the time, but the buffer zone has shrunk in the last few weeks, and there was more people obviously out there today than usual. But I wanted to play this piece because it shows Karen Reed coming out of the courthouse after today. What did they let them go home at 4:30, right, Ed? The jurors?
Yeah.
4:30. Okay, yeah. So this is Karen Reed coming out of court, and let's just listen to this little piece here.
In the Karen Reed case, headed home for the weekend after the start of their deliberations. They have strict instructions to not do any research or speak among themselves about the case outside of that jury room. This came after hours of closing arguments from lawyers, then more jury instructions from the judge.
Now, Reed's future hangs in the balance with those men and women tonight. Our live team coverage kicks off with WBZ's Christina Rexon-Dedham, who has been following this trial since day one. Christina?
Lisa, and this second trial is such a different trial than Reed's first. Obviously, there's a new jury, there's a new special prosecutor, there are additional defense attorneys. And even though it's been such a different case with new evidence, there's still one fear in the balance, and that's the possibility of another mistrial.
That's possible. Karen, any work that makes you feel confident that you could avoid a mistrial this time? Or is that a fear?
We've done everything we can, the instructions, the verdict slip. You've seen us fighting in court.
Karen Reed's fate is in the hands of a 12-person deliberating jury after lawyers delivered a last pitch of what they say happened, starting like this.
John O'Keefe was 46 years old. He spent his life helping people.
There was no collision. There was no collision.
The defense starting its closing the same way it began the trial, by telling jurors that the data shows there was no car crash.
And John was not struck by a 6,000-pound SUV. Period. Full stop.
Alan Jackson told jurors that Brian Higgins, who was not a witness in this trial, coaxed John O'Keefe to the house that night, into the basement or garage, and that this possibility was never investigated by since fired lead investigator Michael Proctor.
She's a whack job. No, zero chance she skates. She's. And up to this point, Michael Proctor had done zero investigation.
I want to make it clear here. We talk about this all the time, Ed. What Attorney Jackson is referring to here is that 16 hours into the investigation, he sent those text messages calling her a whack job cunt and all those nasty things that he said about her. And he also had his mind made up, and he hammered this home to the jury without any objections. This is what was great about this. And unfortunately, as per the jury instructions, they cannot use the closing arguments in their determination. They're supposed to take the facts of the case, and so they got specific instructions, but they're hearing this. Ed, I wanted to get your thoughts on how important that was, that he hammered home that less than, I think it was 16 hours, he sent those text messages and said the girl is going to catch, the homeowner is not going to catch it, the girl is going to something like she's going to be charged, or the girl is going to take the brunt of this.
Right.
It's important.
Right. I mean, during the trial, they talked about confirmational bias. Now, at this point in time, he interviewed Jennifer McCabe, her husband, and I forgot who else it was there. Was it Terry? I'm not sure. Yes, it was Terry. And so after interviewing 3 people, he made up his mind that Karen Reed was the guilty party and that it was a vehicle accident.
Right.
Not having been to the scene, not having looked for any evidence, not having viewed the vehicle. Just that. I mean, during those interviews, we don't know what else was said. Okay. We don't know what else was discussed. Okay. That involving this case. We don't know any of those things that may have been going on in the background. Okay, favors being asked, protect this person. You know who this person is. When we got to take care of each other. Or, we don't know any of those things. Okay, but something happened that, boom, the blinders came on to the lead investigator, and the target was Karen Reed.
One of the key words in that text string to me was the powers that be want this cut and dry. And when you hear the powers that be, it reminded me, and listen, the NYPD was a huge police department, much larger than Canton. Obviously, we had up to 40,000 members at any given time. Now we're in the 30s, but a 30 some odd thousand member department. When you would get when something heavy would go down, or something newsworthy, or something that was, high profile, the chief of detectives, the head honchos, if you will, I'm trying to talk in layman's terms here, Ed, but the big bosses would say to us, the small low line detectives and the people who are out there doing the work, get this case done, but do it right. This rings true to me of that the powers that be, meaning Massachusetts State Superintendent of Police and Canton PD police chief, they got together as executives and said, we want this case closed ASAP. And on that night, in 16 hours into this investigation, he said the powers that be want this cut and dry. Man Brown Jr., thank you for putting me on track. He said she's going to catch some serious charges. That was his exact words. But Ed, your thoughts on that, the powers that be comment?
Well, we can also see that later on in this investigation that the police commissioner of Boston got involved as well. So yeah, there was a lot of high-ranking officials putting pressure on their subordinates. Now, But the problem is the evidence doesn't support what they're doing. Now, they thought she was going to cop a plea because they dumped all these charges on top of her, right? And they didn't think she was going to fight. And you could see in the text messages in that group with the McAlberts, it says, all right, if she pleads, it's done. If she fights, it's going to be an episode.
Yeah.
Okay. So we got the episode, right? They didn't get their plea. So the problem never went away. And they hadn't done any investigation at that point. They hadn't collected the evidence correctly. They hadn't processed the evidence. They hadn't done any reports. They hadn't done any interviews. They hadn't done anything.
Yeah.
Okay. You know, if he really had pressure on him to do this right, then it's all on him. Okay. Because he didn't do anything right. Nobody did anything right here. They did everything wrong.
From the beginning. From the beginning. And as you say, crap in, crap out. This investigation was never an investigation. And a lot of people, this will ring true to our true crime audience. These cops, all involved from the beginning with Lieutenant Leafblower, Lieutenant Gallagher, right up to Trooper Proctor, all did not do a proper investigation for a reason. Not because they were stupid, not because they were this, because of that exact statement 16 hours into it by Trooper Proctor. The powers that be want this case closed. They want this cut and dry.
Now, there's proof from other investigations that these players have done that they know how to do it right.
Yeah.
But they chose not to do it right here. And it was for a specific reason.
Correct.
And it was because their target was Karen Reed. Now, something popped up in my head. I should have thought about it earlier, but it really came to me because I had a similar case. When they went to Karen Reed's father's house to seize her car and her phone, they had no warrant.
No.
Okay. That was a custodial interview. When they went there, she had just been released from the hospital, right? And she's coming back to her father's house. Now, why did she go to the hospital? Because they psyched her.
Right. Yeah. They did.
Okay. So if you were psyched and you're suffering trauma from discovery of the loss of your boyfriend, and then you were psyched in a hospital, and then you were released, and you were given meds, and then you go to your father's house to try to decompress, and then the police show up, you can't give consent.
Right.
To give up your phone or to give up your car. Law enforcement should know that you're trying to get consent from somebody that is emotionally unstable at this time. And so you can't do that. You know, we're taught that too, folks.
Right.
We're taught that.
Yeah.
Okay. That you can't do that. So you need to go get a warrant. So her giving up her phone and her giving up her car may not have been legal, but nobody made that argument. It only came out towards the end of the trial when they were, who was it? Which defense attorney was talking to the judge about their, what they were going to be arguing in closing for their defense.
Alessi.
Okay, I don't think it was Alessi. I can't remember. Anyhow, but
the only other one it could have been is Yannetti.
Yannetti, that's it. Yannetti was doing it.
Yep,
okay.
Yannetti.
Yeah, not Alessi, but Yannetti. And so Yannetti was going back and forth with the judge saying, we're going to talk about how they didn't do a proper investigation and blah, blah, blah. And that's when it came up because the judge said, well, what are you saying? That the seizure of a phone in the car, that was illegal because, it was a custodial interview. And, that's where that conversation, then it popped in my head because I had a case just like that. I was being asked, being pushed by a lieutenant to go into somebody's apartment, without a warrant. And he said he got consent. And I told him his consent was no good because you're saying the man was so distraught that you took his gun and shield away from him because you were afraid he was going to hurt himself. So if he was that distraught and and you thought he was unstable and you took his gun and shield away from him, guess what? You can't get consent from that kind of person. And we went back and forth, and finally I said, you know what? I'm calling the legal bureau, because we have a legal bureau at headquarters. So we call there, and the lawyer there, the lieutenant and I get on the phone with the lawyer, and then the lawyer tells the lieutenant, detective's right, you're wrong, you need to go get a warrant.
Yeah, when someone's in that state, you cannot get consent from them. So
yeah, I mean, so nothing was done right here, nothing. Okay, and it, you know, the proof of that taillight not being broken came with the sergeant's testimony, and then it was backed up by forensic science showing there was no saltwater stains in the interior components of that taillight. That means that taillight was broken in the Sally Port out of the snow and rain and the salt. Okay?
When Brian Higgins was inside there with Chief Berkowitz, that was inside that Sally Port, when police officer Dever said they were in there for an outrageous or ridiculous amount of time. There we go. Let's listen to a little bit of closing arguments with Alan Jackson. We're not going to listen to it all because it's an hour and 24 minutes, but let's listen to the opening part just for a couple of minutes here, because he really comes right out of the gate, and he really delivers a powerful message here.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us.
He accentuated some because he was referring to Sergeant Barrows, the Dayton police sergeant, who was a police officer at the time. I don't think he a sergeant at the time. He might have been a sergeant, but whatever the case may be, he was the only honest one that came forward and said that taillight was not in the condition that it was in this photo when he saw it when they picked it up from Karen Reed's father's driveway.
One of the only honest cops that testified in this trial, and Hank attacks him in his closing.
Yeah, I mean, it was a bad look for him as it pertains to the jurors. Let us know what you think in the chat. And also, I'd like to always engage the live chat. If you guys can, let us know when you think this verdict is going to come down. Is it going to be Monday after the break in the morning, after lunch? Will it be Tuesday? Because as the days go on, if it doesn't happen by Tuesday at lunch, my concern is that there could be a problem within the jurors coming to an agreement if it doesn't come down Monday or Tuesday, because this is so straightforward. So in my opinion, and I guessed wrong in the first trial, I thought that they were going to come right out with a verdict, but I'm going to say it again because this one was different. There was less witnesses for the Commonwealth. I think they brought out 68, and then this one it was 38, so 30 less witnesses, and a much better presented defense, I feel.
Yeah.
Ed, your thoughts on that?
There's two different defenses here. The first defense was third party culprit, right? This wasn't third party culprit. This was incompetence by law enforcement, okay, in their investigation. So, you know, even though they talk about Brian Higgins in here, but they didn't get into that because they didn't have Brian Higgins on the stand. They didn't have Proctor on the stand. They didn't have the McCabe's on the Jen's husband on the stand. They didn't have the children. They didn't have all those other people on the stand. So this was, there's no accident. There's no vehicle accident. They just went strictly down that and the improper investigation. And I think that was the smart move to do.
Absolutely.
Because think about it. All those charges against her, except for one, which is the OUI, all those charges involve a vehicle accident. All the lesser minor charges involve a vehicle accident. You prove there's no vehicle accident, then all those charges go away. Okay. And I believe the proof is insurmountable. You cannot break down that wall between the medical doctors, the pathologists, and the crash daddies that accident did not occur. He being Officer John O'Keefe, just doesn't have the injuries and the wounds to match the accident.
Right. And did you notice that Hank Brennan did not mention Dr. Scorti-Bello at all? At all. So when you have a medical examiner making a statement that it's John O'Keefe, his injuries were not indicative of a vehicle strike, that's powerful. And the jury is going to take that into the deliberation room with them. They have a lot of information to look over, but that one, and I love that AJ Alan Jackson used your terminology, Ed. It's almost like he's listening to you.
Doesn't lie.
Yeah, the science doesn't lie, and he said it verbatim. Those of you who are watching, who were you thinking of when you heard that come out of his mouth? I thought of you immediately, Ed.
Yeah, it doesn't lie. It's the truth. Okay. People lie. The science, in this case, the physics, the engineering, and the medical evidence does not lie. Okay. And Hank Brennan can talk about debris fields all he wants because that's bogus. He can talk about pirouettes and landing by the flagpole. Didn't happen. Okay. Right. He can talk about being outside from 12:30, whatever, until they found him at 6:10.
Right.
He doesn't have frostbite.
Yep. And after we play this here, and we're going to talk about the possibility is if she is convicted on some of these lesser charges by some remote chance that happens, the time that don't forget, she's out on $100,000 cash bail, right? So if Karen Reed didn't come up with that cash bail, she would be sitting in the county jail. She would be sitting in jail all of this time. So if, let's just say for argument's sake, she gets charged with a lesser charge and it's 2.5 to 5 years or 2.5 years, the time that she's been out on bail, I believe, should count as time in.
Well, if she does get convicted of OUI, which is driving while impaired, right, under the influence, that's the easiest of all the charges to appeal and probably win on appeal. All right. Because as he says in his closing, you can't say what her alcohol level was because they don't know when she took her last drink.
Mm-hmm.
Okay.
And the conversation that she could have drank to soothe herself after
when she was back at John's house.
Absolutely. Absolutely. And that would not seem outrageous because of the shock, as we talked about, the shock of seeing her boyfriend, who she was just having a nice night out with him. He kissed her on the forehead, as was testified to as from her friend Karina. She stated it was one of the most loving acts that she's seen in a long time, or that she's ever seen. And there was no fighting. Yes, there was text messaging because he wasn't answering her. He wasn't coming home during the course of the evening. But I mean, I don't know how many people who have been in relationships where, you know, if you're not answering a phone and your significant other is trying to get a hold of you, they get pissed off.
Well, this was a tumultuous relationship. There's no doubt about that. I don't think anybody can deny that.
Yeah.
And she was extremely jealous. Okay. And there was that incident down in Aruba. Okay. Right. That occurred. And he didn't look too good in that incident. Okay. As to what transpired there. So I don't care for her language on the voicemails but I guess I'm a different generation. I don't, the women that I hang out with don't talk like her.
Yeah.
Okay. And don't use those terms and don't get like that. So I'm okay. But this jury is young and they're tech savvy and around her age. So maybe they understand that more, that language and the hostility in the voicemails and all of that stuff. Right. Okay. I don't like that. It's not me. And I never was with anybody that ever did anything like that. Okay. And I wouldn't be, that's just me. Okay. But that said, there's no proof for an argument in the car, and there's no proof that she ever said, I hit him. Okay. In fact, Jen McCabe's testimony in the grand jury does not say, I hit him. It says, did I hit him? Could I have hit him? In the grand jury. Those are her words.
Right. Yeah.
Okay. But she changed her story. So
let's listen to a little bit more of this. There's a lot of, when you look at the Commonwealth's case, there's a lot of guesswork. And Dr. Rentschler crushed Hank Brennan on day 31 when he said, there's no proof that she ever hit him with the car.
That's it. The bottom line. That's it. I could say I'm the King of England.
Yeah.
That doesn't make it so. Okay. Yeah. The problem, she was going through that grief process that Dr. Russell talked about.
Correct.
Okay. Yep. And so, whatever, it doesn't matter what she said. It matters what the science says. The science says it didn't happen. Right. And you can't get around that with eyewitness, ear witness. The physical forensic evidence of the accident reconstruction, the physics, and the medical findings show John O'Keefe was not hit by that vehicle. End of story.
And in addition to that, you have secondary confirmations from the medical examiner.
Mm-hmm.
Yeah.
Well, it's the totality of the sciences. Yes.
Absolutely. Yarn Barf, good to see you. Hope all is well. She said, claiming on duty while he was drunk. She's referring to Brian Higgins. He was drinking and staggering and carrying on like a fool and doing all of those aggressive maneuvers at the end of the night at the waterfall towards John O'Keefe. And Alan Jackson put that side by side, clear as day for the jury in the courtroom today. Thank you, Yarn Bar, for being here. Thank you to everybody for being here. Let's listen.
Innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. And for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins's mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
Are these men or school kids here?
Yeah,
I mean,
they're testosterone, alcohol. What is it called? I'm sorry. Social lubricant filled morons.
Yeah. Assholes.
Okay. All right. They're peacocking there, and for Jennifer, Karen's attention, and he's not getting it.
Here's the side by side when he is exiting the bar, and they have the split screen where John O'Keefe's over here and Brian Higgins and company are over here. Let's listen to this. There's John. This is Higgins. Outside. Let's go.
Yeah. See, I've seen this too many times. Drunken cops, who think they're above the law because they are cops. They get away with this because they live in this cop town. There's this incestual relationship because everybody in this town is related to each other, or 1 degree of separation, or whatever else is going on in this town. Yet they were going to go outside and have a fight. Okay. And it just didn't work out that way. All right. Because Jen tried to separate Karen from John, and so that fight could occur, but it didn't. Karen stayed with John, and then they kept inviting them back to the house because then the fight was going to occur at the house.
And what about the text message from Brian, from Higgins?
Are you coming? Yeah. And then all the text messages from Jen, which she deleted, by the way, because all those phone calls and text messages to John O'Keefe were deleted from her phone. The only reason they found them because they were still in John's phone. Okay. So
yeah, interesting. Let's listen. He talks about 34 Fairview here now.
He had access to the exact same thing that you saw. Why did he do nothing? few minutes later, Higgins then texts John directly. "You coming here?" 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? "You coming here after this?" And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house, about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. "You coming here?" Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property.
That is huge. Ed, you and I spoke about this extensively for many weeks. The fact that he never came out, the fact that he never offered to have his house cleared, the fact that the chief of detectives who lives across the street never came out and provided the red Solo cups and the Stop and Shop bag. Huge.
I teach a course for the Department of Homeland Security called SPOT. SPOT stands for Site Protection Through Observational Techniques. And we teach law enforcement how to profile behavior, to understand what is the baseline for that area that you find yourself working in, what should be there, what shouldn't be there, and what behavior is an anomaly to the event that you're trying to protect, and so forth and so on. Now, let me give you an example of something that occurred here with the Boston bombing. If you remember, the FBI gave a press conference showing surveillance photographs, CCTV images of black hat and white hat. Two individuals they identified in the crowd along by the finish line, and they had photographs of them and asking the public for help in identifying them. Do you all remember that? Okay, which is bullshit by the way. Why? Because those two brothers were interviewed by the FBI Joint Terrorist Task Force from the Boston field office weeks, months before the attack. Okay. And they had a folder of these two brothers with their photographs in it because they were tipped off by the FSB from Russia that the oldest brother was making trips to Chechnya and he was radicalizing and becoming a terrorist. Okay, just put that in the back of your head. Now, there's a videotape of the younger brother walking on the sidewalk when the older brother's bomb goes off. Everyone around the younger brother at the time does what any normal, reasonable person would do in that situation. They turned and looked in the direction of the bomb that just went off. But he didn't. He didn't turn. He just kept walking away from his backpack bomb that he put down. Now, why did he do that? Because he knew that was his brother's bomb. And he knew he had to get away from his bomb, okay? So that behavior that he demonstrated in that security video showed an anomaly in what he did to what everybody else did once that first bomb went off. And I tell you here, Jen McCabe did the same thing in front of her sister's house when she did not run up and knock on the door and try to get in her sister's house to see if they were okay inside that house.
Right.
And the reason she didn't do that is because she already knew what had transpired.
Right. And she didn't even make an excuse, Ed. She didn't even say, well, I was scared to go in there because I thought the boogeyman was in there. She didn't even say that. She just said, oh, I tried to call her and she didn't answer twice. So you would think that she would have said to the cops that were there was extra police there, hey, could you go check on my sister and my brother-in-law? Because there's kids also too in that house. There was a bunch of 20-year-olds in that house partying for a birthday. I don't know how many stayed over. I don't know what, like there was nothing like that. And your example as it pertains to the Boston bomb and this case is perfect. Perfect.
It's the same thing. It is the same thing.
Same
okay.
thing.
All right. Her behavior was not normal for that situation.
Agreed.
If anybody here, is it reasonable that she did not go and check on her sister and her brother-in-law in that house? You have a friend that he's a cop, and that's another thing. That was not reasonable. She didn't tell 911 that there's a cop on the ground here, right? Right? Why? Because she didn't want all the police to respond. She didn't want a full-blown police response to come. Okay. So again, her behavior tells you she knew what was going down.
Agreed. And I think the general consensus is everyone agrees in the chat. Kristen started a poll in the beginning of the video. She said, we asked the live audience, what do you think the verdict will be? Guilty, not guilty, hung jury, or guilty, but not on all charges? So the guilty folks were 5%, and not guilty, 82%, hung jury, 8%, and 5% said guilty, but not of all charges. The poll has 2,700 votes, and it keeps swelling. It's swelling as we speak. So make sure you go and cast your ballot in that poll. Let's listen to a little bit more of this, and then we got a couple more things we want to get into. We want to get into the super chats, and we want to talk about what the future holds here. Again, the jury has the weekend off. They're going to come back in Monday morning and start their deliberations immediately. And we're going to talk about the breakup. 5 women and 7 men is the breakup of the jury. The foreman is a male was seating in seat number 1. He's African American, and Judge Bev went to him immediately. There's a lot of people that are pissed about it, but I think according to Massachusetts, the laws in Massachusetts or the courts or how they run, this is what they do. I don't know. It didn't sound right to me. I thought that usually the jury gets together and they vote on who is going to be the foreperson, but that's not how it went this time. So
No, the judge always picks it.
Okay, so there you go.
Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scorti-Bello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scorti-Bello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV, period, full stop. Dr. Dan Wolf did the testing on the taillight, actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing, actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory.
And I want to try to get to the part where he describes Trooper Proctor's conclusion that he came to in hour 16 of this investigation. So if you could just scan the chat. If there's any questions, #Ed, #DutyRon.
Sure, I got it.
In a few minutes. So I want to just say Thank you to everyone that's been in here, all the super chatters, all the folks who are positively engaging. Again, I'm just going to try to find it. I'll put Ed full screen so he could check the chat.
Yeah, I've been watching in the chat, and I saw some things, and some things I disagree with. And there's no doubt that the damage to the hoodie sleeve, I'm wearing a hoodie sleeve, was caused by a canine, was caused by the dog. No doubt. The puncture wounds in here are circular and then elliptical, elongated as entry and pull, entry and pull. Any of us who have a dog, in fact, I have sweatshirts that my dog, fooling around with me, destroyed. I wore those shirts specifically to roughhouse with my dog, Kara, when she was a puppy. And that's exactly how she did it. Okay. And then anybody knows that when they lock on, right, and they get that first bite, they will then pull down and back, down and back. Okay. That's instinctual. All right. And so you know that. Those are circular entries. Look at the shards of plastic. None of them have any circular geometry. How did they make that puncture hole? The puncture is the entrance, not the elongated elliptical damage. The puncture is the entrance, and the pulling is creates the elongated. What geometry on the plastic could cause that? So when people are saying it's not a dog bite, it is absolutely a dog bite. And understand this, there are more injuries to the arm than damage to the clothing. Well, how does that happen? It's simple. Once those teeth get in here into the shirt, the dog can release the bite without coming out of the shirt, shift the shirt, and bite back down while the teeth are still in that position. Look at the shirt damage. With the exception of one, all of them are two parallel punctures, except for the one by the elbow. Okay?
Thank you for pointing that out, Ed, for some of the people in the chat and some of the people who watch on the replay. We love our replay viewers, and we thank our moderators as well. You guys are what makes this a great place. And people like Black Rose 11, Dawn Marie, Joey Brooklyn, and all of our friends like Kim Robinson, Makeup Mobster, My Crazy Life, White Rabbit 1701, Joey Martinez. Thank you all for being here. We appreciate it. I just want to say one other thing too is there's so many people, so many great people that are covering this trial. Like you got the lawyers, you got retired law enforcement, you got people who just pay attention to details. You got the sleuths that are out there like Sleuthy Goosey and all these other different ones, Olivius Benson. They cover these cases and spend hours on it. So I encourage everybody to go and check everybody out that does cover this case. Let's listen to Alan Jackson as he talks about Trooper Proctor. Some of this language might be a little bit rough, but it's important for us to hear it because the jury, they certainly did hear it and they certainly know what was happening as it pertains to his investigation.
The man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, There was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm.
And Ed, I mean, you're a DNA forensic expert. You know from crime scenes processing over 2,600, 25 and change crime scenes. Heck, there would be some DNA and something left behind because that Lacard's exchange principle comes into play, no?
Typically, yes. But again, we don't know how the clothing was actually taken care of in that environment. We don't know what the temperature of that room was because excessive heat could destroy the genetic markers. Exposure to UV lamps could expose genetic markers. Okay. And I would have preferred the wounds to have been swabbed because that would have probably yielded a mixture of the dog's DNA, maybe the pig's DNA, and John O'Keefe's DNA.
MC, the answer to that question is no. They did nothing properly. Zero.
Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. It tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sallyport. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs.
And he's not bullshitting because we saw the pictures. That hair survived what he just described in a nor'easter.
And don't forget the avalanche of snow that fell down the side of the vehicle from the roof. And it washed right over it, and it didn't wash that hair away.
We watched it in a timeline, the playback of the timeline inside the Sallyport. Unbelievable. He gets into Proctor here now.
But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael.
Ed, your thoughts on that? Because I have something funny to play. I want to put you full screen.
Yeah, we knew that, though. I mean, we knew that. That was a big leap. Nobody knows where that glass came from. It didn't come from the taillight because the taillight has no glass in it.
I'm just going to play the soundbite because
also.
And why is that, Mr. Reed?
Because it's devastating to my case.
I got to play it one more time, Ed, and watch your reaction.
Your Honor, I object.
And why is that, Mr. Reed?
Because it's devastating to my case.
Overruled.
Good call.
Jim Carrey. God. Right. But some of the plastic parts that were recovered on the front lawn by the search team doesn't come back to anything belonging to the taillight. So where'd that stuff come from? Was that a bait and switch kind of operation going on there?
Another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. A piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. 9th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said the very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical location data using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood.
That's the travesty of the justice right here. That is what makes this thing such a sham, is that they never went into that house, Ed. And people have talked about them ripping up the basement, taking up the floor and renovating, putting the thing on the market. We heard the homeowner, Brian Albert, say that, oh, we were planning in 2021 to move on. We heard him in the first trial. It was bullshit. We had this plan in place, this master plan. But as soon as John O'Keefe shows up murdered on your front lawn, you pull the trigger and you get out of Dodge. You get rid of your dog, you get out of Dodge, you deny any access to your home. Like, I think Gallagher, Lieutenant Leafblower, and Buchanan, or one of them, went into the house but was just in the mudroom and in the kitchen area. They didn't go anywhere. Just out of this world. It's like, this is like if you told somebody the story, Ed, that had no clue that this case existed, they would be like, you're full of shit. If we told the story to one of our fellow brothers and sisters. Let's go to the super chats, Ed, because I thought that he talked about Trooper Proctor, but he really just...
He did. He talked about him in the beginning.
Yeah, I played it from the beginning, but I thought he went into a little bit more detail in that clip, and I'm relying on other people's clips. So let's go to the starred super chats and say hello to everyone. Kayla, thank you. Appreciate the $2. Danielle, thank you so much for the 10. What are your thoughts on the jury selection today? Why would Aunt Bev not allow it to be transparent? And again, I understand, Ed. Ed, you were around the attorneys. Did they speak about this? They do that.
No, well, I mean, I witnessed it firsthand when I watched it, that she denied it, so that, that's on her. That was a simple, easy request that she could have accommodated, and it wouldn't affected anything. But now, if something happens, there's potential blowback on her.
Yeah. Ida, thank you for the $5. I don't understand how anyone can say Karen Reed is guilty. The injuries are not consistent with the crash. Blows my mind. Scrolled and X scary. Yeah, it is scary. It is scary, but a lot of people don't look at this thing with a clear lens. That people have blinders. We do look at the totality of all the evidence, and when you do look at it that way, there's no way you could logically come up with that she's guilty.
I can tell you how many times witnesses said something or they saw something, they thought they saw something, and that information gets relayed to me, and I look at the crime scene and I say, nope, it didn't happen that way.
Amazing. Charleston Amy, yeah, it is what it is, and you can't force somebody. You can lead a horse to water, but you can't make them drink. It's the same concept here. Charleston Amy, thank you for being a member for over 50 months. She says, thanks for y'all's continued service. But we appreciate you being here for such a long time and being a member. Kayla, thank you again for the 2. She's accusing you of stealing her line, Ed. I don't know when that was.
What is this, like it's her line, not her move, right? This isn't like Seinfeld, right? That's my move.
Insomniac 49, thank you for being a member over 37 months. Thank you all for your coverage of this. Every other case you cover and every other case you cover. Do you think there will be another retrial of hung jury? Yes. Yeah.
I don't think this. If Morrissey is the DA, I don't think he can let this go.
You would hope not. And you say this all.
I would hope he would. I would hope he would let it go, but he's not going to let it go.
He's not going.
He's corrupt.
But you said, and I agree, in any of the 5 boroughs here, any of the New York counties, no district attorney with good faith would look at this case and say, "You guys got enough. Let's charge." They would tell us, "Get this thing out of here with 343 in your case." It wouldn't even make it to a grand jury. I mean. This is
right.
It's just so ridiculous. So thank you for that. I love kitties sends in 10 and says thanks for all you've done and continue to do. You both are amazing. Well, thank you. We couldn't do this without our live audience. Another thing too, like I was thinking, Sergeant Buchanan, he made a statement and like, look, this is probably not, it doesn't apply to everybody, but like he said, I don't, when he asked about the dog and the rehoming of the dog, it was that whole awkward questioning. He's like, I'm not a dog owner. If you're not a dog owner, if you don't like dogs, like he appeared to not like dogs, I don't like you. So, or cats or any animals. But he said that on the stand, I'm really not a dog owner. I don't know. Yeah, you can call it rehoming. Maybe that's what people do. They adopt out their dogs. Get out of here. Texas RN, thank you for the 10. Can you both give your thoughts on the added charge of OUI? It baffles me.
Well, that's operating under the influence. And I believe the defense actually asked to put that in. And I believe that came from the last trial and the interviews by 2 of the jurors, the bow tie guy and somebody else.
That guy,
where they talked about, what they believed and what they didn't believe. And I've seen this firsthand in New York. We had a sergeant who was murdered by his wife while he was taking a shower. She took his 2 guns and emptied his guns into him while he was taking a shower. She was arrested. They went to trial for murder. And then the jury only convicted her of possession of the firearms, not the murder. Okay, so they were hung in the last trial here. And so it's kind of the same scenario. They were hung in the last trial. They had problem, 8 to whatever it was, problem with that last charge. Okay. So I believe they threw this in because it's a misdemeanor. So that, if someone in the jury is just acting on emotion and not facts and common sense and reasonableness, and they're hung on a charge, that this charge is there to help that person who just doesn't like Karen and wants to convict them of something. Okay, it's a crazy tactic, but of all the charges, all right, she can do 2.5 years in prison for this charge if convicted, but it would be the easiest to appeal and win.
Right.
The appeal. So that's the strategy that I'm seeing.
Yeah. And I don't know. I mean, I'm not sure about the legal part of this, but I think because she paid that $100,000 cash bail and she's been out, if she did not pay that cash bail, she would technically be in custody. So I think, when you post bail, it's sort of like you're in custody, because you have to surrender your passport, you have to surrender your driver's license. She can't drive. They have her car. She's basically a prisoner within her own home. She can't travel outside the United States. She can't go and travel to freely without notifying the court. So I think technically these 2-3 years that she's been in custody and out on that bail, that would count if she got charged and say got sentenced to 2.5 year to 3-year sentence. The time that she's out on this bail would count as time served towards a sentence. I'm going to look that up, and I'm going to get with one of the lawyers. I'll ask one of our criminal defense attorney friends. Here's Karen Reed's dad outside of court this morning before opening arguments. Let's listen to what he had to say.
How are you feeling?
Feeling great. Any comment? Well, I wish I wasn't here, but this is what corruption is all about. Just look at the injuries. They don't correspond to being struck by any vehicle. I want justice for John O'Keefe, but that may come at a later day. It's all about the science. You heard Dr. LaPasada. You heard the ARCA witnesses, the scientists from ARCA who are hired by the U.S. Attorney, the Department of Defense. Sorry, Department of Justice. Check that. And so, this is the final stage for us. This kitchen. Attorney Jackson on his closing. Digest it all. Take it in. Because someday it could be your son or your daughter. God forbid.
Well said. Someday this could be your son or daughter. God forbid.
That's another thing. I'm glad you brought that up. In his closing, Alan Jackson, I would have added something like this to ladies and gentlemen of the jury. I want you to close your eyes. And I want you to think about all the evidence that the Commonwealth has brought to your attention and shown in this case, and all of the evidence we've brought to your attention and shown in this case. I want you to think, did the Commonwealth meet their goal? Did they meet beyond a reasonable doubt that these charges occurred, these crimes occurred? Now I want you to think that you're the defendant, not Karen Reed, in this trial.
Put yourself in that position.
Yeah. Do you think they met their burden beyond a reasonable doubt on all of these charges if you were sitting in Karen Reed's spot?
Yeah, that would have been interesting, but he didn't say it. But yeah, I mean, there's so much you could think of after the fact. And I'm sure that there was a lot of thought that went into that closing argument by Alan Jackson. He did a great job, and he obviously could have added more to it. But I think he really hammered home the finer points, and that is that the Commonwealth did not prove the burden. The burdens of proof is on them. They did not prove beyond a reasonable doubt that Karen, in fact, did commit these crimes. Let's listen to this. This is Karen outside of court after the jury were sent home. This is probably around 5-ish. They went home at 4:30.
It's very well, very well. Thank you.
Your side.
I don't think mine could have gone better.
What do you want to
That's
say?
all I'll say.
What does it feel like now that it's in the hands of the jury? What does it feel like? Can you just describe what that feels like?
I'm anxious, ready.
You said butterflies. I mean, it's been an hour and a half, 2 hours. Does that tell you anything, or how do you look?
Who knows? Who knows?
Any message for this jury? I mean, they've heard all the evidence, and you've heard it all. What's your message to the jury?
I don't have one.
Nothing at all.
No.
What do you plan to do this week? Give her some room. What do you plan to do this weekend?
I'm gonna try to sleep. I don't know if that's possible. But I'm gonna try.
Any work that makes you feel confident that you could avoid in this trial? Or is that
We've done everything we can. The instructions, the verdict slip. You've seen us fighting in court.
What's it feel like to
Do you think you did enough?
time?
What piece of evidence do you think the jury should keep in mind to make their deliberation?
So a lot of silly questions from the reporters that she can't answer. Ed Wallace is searching for data. I know him very well.
I'm searching for data. Yes, I am.
He's data mining right now as we speak. So that was it. I wanted to play the Karen Reed's reporters outside. I don't want to forget about them because they're out there day in and day out. So let's just play this little piece. This is some coverage from outside the courthouse.
Hey, good afternoon, Ben. Now, Dedham police say there are more than 250 supporters surrounding the courthouse, and that number is growing as the afternoon unfolds. Many of these people have been here long before the courthouse even opened this morning. As you can see over my shoulder, many of them are camped out here on the lawn just across the street from the courthouse, and they say they are here on verdict watch for as long as it takes. People have come from across Boston, New England, and beyond. This afternoon, after closing statements, Karen Reed's defense attorney, Alan Jackson, came out to speak to her supporters, asking them to respect the buffer zone around this courthouse.
We love you guys. This means more to us than you can imagine. But if the volume comes up even a little bit, we're gonna be ordered to stay in the building, and y'all are gonna be ordered off the lawn.
Now, that sign that Alan Jackson gave Reed supporters is the universal sign for I love you. Security remains tight here outside the courthouse with both state and local police making sure the buffer zone around the courthouse is honored by these observers. Coming up tonight at 5 o'clock, we will have much more on those who have come to see Verdict Watch here in Dedham.
So there you have it. Ed, you got your data. I can tell that you've come up with your facts. And what do you got? And what is this about?
So, I said what I said because I'm not a lawyer, but I was just spitballing with, to put yourself in my shoes or put yourself in the defendant's shoes. And some people in the chat said that it wouldn't legally be allowed in the Commonwealth to do that. And I Googled it, and they're right. It wouldn't legally be allowed in the Commonwealth.
There you have it. All right. So Ed, honorable guy. He Googled it and checked it out. And thank you for that, Ed. BN Trouble 31. Good to see you. Hello. And thank you for being here. And thank you for everything that you've done as it pertains to Taillight and the testing and your videos. Everyone should go and subscribe to BN Trouble 31. All right, we asked, what do you think the verdict will be? 3,825 people have voted in this poll. Will the verdict be guilty, not guilty, hung, guilty, but not on all charges? The guilties say 5% out of 3,800. 82, astounding 83% now. It just changed as I was talking. Said not guilty, 8% hung, and 4% guilty, but not on all the charges. So that's where we stand. Somebody's requesting something, Ed. You just hold on. Just let me get ready. You get ready.
Kiss me. What you gonna do? What you gonna do when they come for you? Bad boys, bad boys. What you gonna do? What you gonna do when they come for you? Kiss me. You won't regret it.
Kiss me. You won't regret it. All right, so we are on Verdict Watch starting Monday morning. When did the Bev say they've got to be back 9 a.m.
9 a.m.
at the courthouse. I anticipate either Monday or Tuesday, and I know those aren't fair guesses because I'm given 2 days. But I would say the longer it goes, the more worried I would be. They should, Ed, correct. I don't know what. It's not even a correct me if I'm wrong. This is my opinion. If it takes them longer, then that means that they all can't get on the same page as it pertains to the Commonwealth not proving their case. And we see it pretty clear. And I would hope that they do. And if they do, we may have a verdict on Monday.
Yes, let's just hope that they're being analytical, they're being reasonable and using their common sense and not emotion.
Yeah. Hashtag Ed, hashtag DutyRon. We're going to take the chat, live questions from the chat, and then wrap it up. That's a super chat coming in from I Love Kitties. You both are amazing. No, you are, and we thank you for being here. Thank you for the 10. Bada Bing, Bada Bing, aka Divon sends in the 2. You guys are worth $1 million. Wow.
Bada Bing, the Bada Bing Club, Tony Soprano.
Bada Bing. Sharon, thank you for the 2. Do you guys think still the feds are on the case?
I hope so. I hope they're watching this.
Yeah. Bobby Page, thanks for the 5. Not that I was already leaning not guilty, nail in the coffin until it was mentioned in closing. Did not realize no outer coat. Yeah, he wasn't dressed for outside. A lot of people said that. You're not alone, Bobby. Oh, look at the picture. It's a not a smiling judge there. I'm not sure what judge that is, but
it's supposed to be lifeguard Beb.
Thanks for the 5. I know. My home is in Norfolk County. I pay high taxes. I want a fucking refund. Hank, 1 million. Spud, 400K. I'm disgusted. You should be. You should be outraged. Brennan's dye job, aka Frankie. Thank you for the 10. New Yorker here in Tennessee. I often wear my FDNY hat to honor and remember people of our many 9/11 heroes. Love and thank you both for your service and sacrifice. Thank you. Where can I get a legit NYPD hat? Well, I mean, they sell a ton of them, knockoffs all over Canal Street, and you can get them online. But Ed, where could you get a legit NYPD hat?
Okay. Send your name and address to DutyRon, and let's see if we can't find one for you.
All right. That means Brennan's dye job, aka Frankie, send the email. You know what's going to happen, Ed?
Yes, I know.
10 people are going to be like, can I get the hat? It was me. It's me. All right. Vinny McCormick, thank you for becoming a YouTube member. CRR, thank you for being a member for over a month. I'm a dog groomer. I have the same bite on my elbow. So she's a dog groomer. She must have gotten bitten doing her grooming duties. Lane loves movies. Thank you for the Canadian $6.99. I believe she's innocent, even more after the second trial. It's a shameful the lack of justice John O'Keefe will get for the sham of a case / investigation. I agree. Look who's here, our good friend K. Me. Thank you for being a member. Thank you for being here, and we love you and we appreciate, respect you. Thanks for the 2. I hope the jury does the right thing and votes.
I want my $2.
Kimberly, thanks for the 5. Is it possible that they've gotten a jury to ensure a hung jury? They've gotten a jury to ensure a hung jury, compromise one or more of them. I've heard this comment. This is not, you're not alone sending this comment. Many people say this. I don't trust them that it could happen. It only takes one, right? Just need one. Kimberly, thank you. Is it impossible? Not in this case. Nothing is impossible. Jim Beller, thanks for the 10. What set Higgins off? Did John yell, go get your fucking shine box?
Good fellas. I like it. Maybe you haven't heard. You've been in prison a while. I don't shine shoes no more.
Did he call the ass grabbing Brian Higgins a hoe? Nah. Yeah, we don't know because there's no audio, but you could see.
What set him off was the being ignored by Karen Reed.
Yeah.
And the kiss on the forehead by John O'Keefe onto Karen Reed's head.
And
Right.
all of his grappling and his fun, his schoolyard antics, Karen wasn't paying any attention to him. She didn't answer any of his texts back. She probably didn't give him the time of day. She didn't even glance over to him. He probably was trying to catch eye contact with her, just one row behind where they were up at the bar. And he was back in that one behind that long table. He's trying to get her attention. It didn't work. Joe, thank you for the 5. Brennan destroyed his own witness.
Several times.
The defense can't argue reasonable doubt on the theory because we don't have a theory. Yeah. Several times. It was a joke.
They keep moving the goalpost.
Yeah. Joe sends in another 5 and says, I'll go with Sherlock Holmes on this one. Once you eliminate the probable and the possible, whatever remains must be the truth. So this is just so frustrating because we've never seen anything like it. And I don't think any attorneys have ever seen anything like this. Just crazy. Michelle, thank you for being a member for 7 months. She says, congratulations. She said it the right way on $500,000 instead of 500,000. We like how $500,000 sounds better. Sarah, thank you for the 99 super sticker. We appreciate you from over across the pond. Nationally 66 $4.99 manslaughter causing death while driving under the influence is up to 20 years in Massachusetts. Causing the death would mean that they have to prove beyond a reasonable doubt that she struck him with her vehicle, and the science shows that he was not struck. It didn't happen. So nationally 66 and everybody that's out there, okay, it's easy for me to say I'm not so worried about this charge, but they didn't prove it. And if they get a guilty verdict back, I don't know what I'm going to do, but I'm going to freak the fuck out. That's for sure. Texas RN, thank you for the 10. Can you both give your thoughts on the added charge? We are. All right, so we're up to date. We're all up to date. Ed, Joe, thank you for the super sticker. That's 20. Thank you so much. Georgia Peach, thank you for gifting a member. Mama She, 13. Love you guys. She sent me an awesome picture of a Mustang Cobra.
Oh, yeah.
I got to show it to you, Ed.
What year?
Mama She, 13. What year? I can't show the picture because I didn't download it yet. All right, Ed, you hold on. Texas RN, they don't want us to go. They keep sending these super chats. 199. Yes, Higgy Piggy was rejected. You guys rock. Yeah, he's a piece of shit. And again, he's, in my eyes, all roads point back to Brian Higgins. There's no question. And 34 Fairview. The cover-up is not this large, huge collusion. It's a group of people who band together, who are lifelong friends, who know each other a long time, and they will just take this to their grave. It's not like the whole Massachusetts State Police, as some of these, people that are going against Karen Reed and saying she's guilty, and they're poo-pooing this whole collusion thing. It's not a listen, Canton Police Department's a little rinky-dink police department, under 30 members. It's a rinky-dink police department. So it is what it is. All right, let's wrap it up. 4,075 votes, 5% guilty, 83% not guilty, 8% hung jury, 4% guilty, but not on all the charges.
I think you missed one.
Oh, shit. Where is it?
Rhino Girl.
Oh, no. She's sending in $100 from her.
From the United Arab Emirates. Okay.
Yep.
I find myself in the twilight zone when Brennan said he, John O'Keefe, is not a buffalo on a prairie.
Yeah, he did say that.
What? Exactly, Rhino Girl. Exactly.
Turd Ferguson. Turd Ferguson is responsible for Melanie Little's intro, by the way.
Okay.
Birdie told me that. Remember, for 6 months, give us Duty Ron, give us Duty Ed. Shut up and listen to Turd's music. I just read the thing. Thank you for being a member for 6 months, and we appreciate you tremendously. Is this Crocodile Dundee's wife?
No need to shout out the super chat. Just appreciate your amazing show. Two awesome gents. Who could ask for more? Who could ask for anything more?
Happy Father's Day to all the great fathers out there, and happy Father's Day to the moms who have to sit in for the dads that are maybe absentee landlords. So there's many, it reverses. On Mother's Day, there's a lot of fathers step up and vice versa. But happy Father's Day to all you dads out there. My dad's no longer here. Ed, your dad is still with us.
My dad is still here. Ditto to all you fathers out there.
Yeah.
All right. You know what time it is? I'm so glad we had this time together just to have a laugh or sing a song. It seems we just get started. Then before you know it, comes the time we have to say so long. Goodbye, everybody. Well, thank you, folks, for sharing your almost 2 hours with us. We've been doing very long shows lately, but that's a lot of your time, and I appreciate you all sharing that time with us. I appreciate your support. I appreciate you spreading the word about us. And I just want to always say, folks, we love you. We thank you. We want you to stay safe, stay prepared, and watch your six.
Amen, Brother Ed. Thank you so much. And I'm trying to scan the chat. Turd Ferguson saying, Duty Ed, can I clip that and remix it? Yeah.
You can do whatever you like, my friend.
You got the green light, my good friend. All right. So again, we want to thank you. And I'm going to leave you with day 31, a little 3-minute clip. We uploaded this on our channel. There's over 80,000 views on it. It's 3 minutes. And it's Dr. Rentschler just tearing it up. And this is what the jury saw last. His statements, his testimony, it was the best way to end it. And the Commonwealth came back with nothing. So I thought it was really good that they ended it with this. But on behalf of Crime Time with DutyRon and Ed Wallace, happy Father's Day to all the great dads out there on Sunday. Make sure you guys take care of your dads that are out there, because you never know when they could be ripped from you at a moment's notice. I lost mine in 2014 and I miss them dearly. So happy Father's Day, Dad in heaven. I will see you guys on the next one. Monday morning, we'll be back at it. Actually, Monday night. I know Ed will be watching and I'll be at work. So we'll see you guys soon. Enjoy. Good night.
Dr. Rentschler, you were asked a series of questions about a hat, about some shards, about a drinking glass, about a drinking straw.
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. It scientifically, it makes no sense.
Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasions, about an 1/8 of an inch.
You keep saying the physics and the physics. Do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture that doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
Can't deny it. That's the line you were laughing about in the document.